Hello everyone. Okay, so in this particular class, we are going to start a different topic, an altogether different act, which is one of the most longest acts we have in India, that is Companies Act. Company is a beautiful form of business organization, and you can say the most popular choice as of date. Earlier, it wasn't that popular, and businessmen resorted to proprietorship concerns because that was more convenient. And even when they wanted to expand their operations, they preferred partnerships. But recently, you can say this particular form of organization has gained a lot of importance and has gained a lot of popularity amongst business houses because of a lot of advantages, and because you have already read Companies Act in your previous level, and you know a lot about company, you know what company is, you know its features, you know all the basic provisions, that is, you can say till section 122, and a few points about directors are something that you already know, right? But it is very common in all the students, and especially for such a subject which is so theoretical that we don't really enjoy it, or we don't really retain it, right? So in these type of subjects, what happens is students tend to forget what they have read, because exams over, that means knowledge is also over. You can just remove it, and when you go to the next level, now you have to take that knowledge in, right? That is what usually happens with most of the students. Exceptional are always there, and of course I would want to teach all those exceptionals more, but every student is important to me. So even in your study material of CMA final law, what has been designed is few concepts of Companies Act that you have already studied at the previous level are reproduced. Okay, that is the basics of company. Then you also need to know how a company is incorporated, right? So the basics about the incorporation, not very depth, and not very less also. So there is quite some content in the initial chapters are all about something that you have already read. Okay, but you have to read it again. Okay, and there are a few other chapters also, that is Companies Act. If you talk about Companies Act, it is basically it comprises of 470 sections, 7 schedules, and a lot of rules. So every chapter that you're reading is read with some rules. Say for example, when I talk about incorporation of company is read with Companies Incorporation Rules 2014. So that is how we read Companies Act, and as I told you, you already have read a lot of things, but in today's class, and I would say in 2-3 more classes, I believe I am going to teach you everything that you have already read. But it is my inner instinct that 80% of what I'm going to teach you, you must have already forgotten, right? So it's good, because our institute believes to understand the technical concepts, the later concepts which are given under Companies Act, you must at least be familiar with the foundation, right? So to bring that foundation once again in you, those concepts we are going to discuss again, but I will consider this in my mind that you must be knowing at least something, right? So I'm going to tell you everything, but we are not going to go so deep in the first few chapters. Okay, the first chapter, you can say this particular chapter, Companies Formation and Conversion, this is the only chapter that we are going to read a little quickly, but I am going to tell you everything. Since this is something that you've already studied, it is less likely that a lot of weightage is given to this particular chapter. Okay, but still marks are allotted to this chapter also, and we have seen questions also from this particular chapter, so you cannot ignore this in totality. But yes, it is not that very important since it is covered in the previous level also. Okay, so I hope you have got this idea, and now we are going to start with the chapter. What do you mean by company? That is the first question which arises in our mind when we talk about Companies Act 2013. When I'm saying Companies Act 2013, you must be aware that we also have previous company laws. We had Companies Act 1956, and even in Companies Act 2013, you have a proper definition of previous company law which illustrates, which enlists all the laws which have been made till date for companies, right? So basically, company means a company which is incorporated under Companies Act 2013 or under any of the previous laws relating to companies. If you remember the topic of corporate governance, we discussed that there was Companies Act 1956. And then there were a lot of amendments also, a lot of revisions in acts also. So Companies Act 1956 came at a very later stage, and it also witnessed amendments. Even before Companies Act 1956, we had laws 1882 and so on, right? So what I'm trying to tell you here is, till liberalization, there was no concept of corporate governance, right? After liberalization, people started the need to, and after Satyam scam, it became even more important. So Satyam scam was in the year of 2008, and Companies Act came in the year, this particular act came in the year 2013, and it repealed the old act that we had for governing companies. So company concept is not new, but Companies Act 2013 is new. Okay, we had previous company law which does not exist in place now, but this particular act actually was notified in parts. So all the 470 sections are not notified at once, that when this particular act came into force, this particular act got the assent of President on 29th August 2013, but it was not notified on the same date. No section was notified on this particular date. It was actually 12th September, certain sections were notified, then certain more sections were notified at a later date. So this is how it happened in parts. It became effective in parts. In 2014, some sections were notified, and that is how it happened. Is this clear? What do you mean by company? What do you mean by company? If I talk about the meaning of company, it is just few people coming together for a common objective. Their common objective need not be to earn profit. It can be just to do some business, or just to render some charitable activities, as it happens in Section 8 company, that is not for profit organizations. So when certain people voluntarily, not forcefully, voluntarily come together to achieve a common objective, and they get themselves registered with ROC, that is a company. That is a company. Now, if I talk about the definition, this is the definition and this is the meaning. So when I talk about the definition of company, it is defined in Section 2, Clause 20 of the Act, which states that company means a company incorporated under Companies Act 2013. So any company which has been registered under this particular law or any of the previous laws relating to companies. See, if I started my business, say in 1960, I started my company in 1960, I would have got myself registered as a company under Companies Act 1956, right? But this does not exist now. So is my company not called a company? No, definitely it is called a company under Companies Act 2013. Okay. So my company is still a company under Companies Act 2013. That is what this particular point is trying to tell us. The entire act has been divided into 29 chapters, and basically this is not important, and this Companies Act applies to whole of India. If I talk about the applicability, there is every company which is registered under this particular act or previous company laws. This act is applicable to all such companies. What is the exception See, we have certain special kind of companies, that is electricity companies, banking companies, insurance companies, right? For which you must have read a different pro forma of presenting financial statements. These type of companies have their own governing laws also. You have Banking Regulation Act, you have Insurance Act, you have Insurance Regulatory Act also, you have Electricity Act also. So they have their own respective set of legislation also. But they are a company. They are a company. So the provisions of Companies Act apply to these type of companies also. But whenever there is going to be any conflict, say Banking Act says that you must appoint 4 directors and Companies Act say that minimum 3 directors are sufficient, then you have to appoint 4 directors because this is a specific law which governs banking company. This is a general law which governs all companies. So whenever there is a contradiction between the law of banking company, the law of insurance company, the law of electricity company and the Companies Act, which is going to prevail? Their respective laws. Is this clear? That is why it is being said that the provisions of this act, that is Companies Act 2013, shall apply to insurance companies except where the provisions of the said act are inconsistent with the provisions of Insurance Act. So till the time they are consistent or till the time there is not any conflict or dispute, this act is going to apply. But as soon as there exists any inconsistency, then these acts shall prevail. Is this clear? Apart from this, it may also apply on any other company, body corporate, which the government may specify in this particular behalf. When I talk about administration, or you can say authorities, Companies Act, my dear, is administered by the central government and through Ministry of Corporate Affairs, MCA. I hope whatever I am telling you, you are able to relate. I really hope that. And once again, if you have my Telegram number, in case you face any difficulty, you can reach out to me, okay? So basically, this Companies Act is administered by central government through Ministry of Corporate Affairs, okay? And what are the authorities here? We have ROC, we have these official liquidators, public trustee, director. We also have NCLT. We also have NCLAT. So basically, these are the 3 authorities. ROC is Registrar of Companies. Is the main purpose of ROC is to incorporate a company as well as to administer these companies. National Company Law Tribunal is a superior authority to ROC and is as good as the courts for a common purpose, right? If I have a family dispute, I'll go to a family court. If I have a company dispute, company related thing, I will go to NCLT. So this is what it is happening. Then you have NCLAT. If you're aggrieved, if you're dissatisfied with whatever, say if you're dissatisfied with the decision of High Court, you appeal to Supreme Court. Likewise, if you're dissatisfied with the decision of NCLT, you are going to appeal to NCLAT, that is Appellate. Okay, I'm just giving you a prima facie idea of everything. Once we are through with the provisions, you are going to read about NCLT also, its rules also. So everything we are going to get in there. Okay. So I hope now you know what do you mean by company, or you are at least able to recall what is meant by company and how it is defined, what are certain basics, its authorities or hierarchy, and its applicability and extent. Right? Is this clear? Okay. Now, some more basics. Characteristics of company. This sounds too boring, right? Or too childish, too kiddish. Characteristics of company. It is on our tips, ma'am. Artificial person, separate legal entity, perpetual succession, limited liability, capacity to sue and be sued, property in its own name, etc., etc., etc. Right. Very good. These are the properties, and one by one we will quickly analyze these properties also. The first one is artificial person. Now, company is also a person in the eyes of law. Basically, it is a legal person. We are natural persons, so we can see, we can hear, we can speak, right? But company cannot do so. Company cannot do that natural functions because it is an artificial person. So company requires certain people to actually see, hear, speak, right? That is why company cannot run on its own. Company is run by or administered by certain people, right? So company is a legal person, so it has legal rights, but it is not a natural person. So basically company is not a citizen. Company is not a citizen, although it has a domicile. Okay, if company is incorporated in the state of Madhya Pradesh, we say that company belongs to Madhya Pradesh, right? That is the domicile of company, right? But company will not get that citizenship, okay, because it is not a natural person. So that is the difference. Company is an artificial person. Now, this very popular concept, separate legal entity, is associated with this particular case law. Salomon versus Salomon, right? Separate legal entity. What is separate legal entity? Separate. That means their entities are different. When I invest certain amount into my proprietorship business, that is a business, and I am a natural person, but I have invested certain money into this particular business, but still that business and me are the same. See, Mr. X started his own business with a capital of 50,000. Remember, you used to solve a lot of journal entries, right? So what are you going to do is bank account debit to share capital, but to proprietor's capital, right? That is how you are going to write it, 50,000, 50,000. Now, supposedly somebody took a loan. This particular business took a loan from somebody and is unable to repay that particular loan. The person from whom you have taken loan will actually come to Mr. X, and Mr. X might have to pay whatever loan amount is from his own pocket. That means business and Mr. X are considered as the same entity. It makes no difference what you are doing. It is your business, it is you only. But when we talk about company, this is one of the most beautiful feature of company because it distinguishes the members from its company. It distinguishes who is doing work and for whom it is done. For whom it is done, on whose behalf it is done, that is more important. Okay, so a registered company is regarded as a legal entity which is separate from its members, and so it can own property, it can have a bank account in its own name, it can raise loans, incur liabilities, and do all of it. This is a case law which is, this particular point is substantiated by this particular case law. What happened in Salomon Company? Salomon was a person who had a proprietorship business and was doing good. So he decided to form a limited liability company. Limited liability company, it is a company in which liability of members is going to be limited. Okay. So Salomon started a company, and who were the shareholders of the company? It was Salomon himself, his wife, and his daughter and his 4 sons. So he started a company and there were these many shareholders. So as you can see, there is no outside shareholder. There is no outsider. They are all family members only. But when he had a proprietorship business, all his liabilities were of his own. But when he formed a company, the liabilities of the company are different, and the liabilities of Salomon and his family are going to be different. Okay, because there is a clear distinction. That company is a different entity and you are a different entity, right? Is this clear? Now what happened is, all the shareholders were holding one share each, and all the remaining shares were held by Salomon. What he did is, he sold the business to the company for whatever amount, and company issued, this is Salomon, his business, proprietorship business, and this is his company. So what he did is, he formed a company, sold this business, and company paid amount to Salomon. Why? Because he became the shareholder. Okay. See, if I have my own business and I'm going to sell it to a company, that company is going to pay me something, right? Company can pay me cash, company can issue shares of the company, right? So company, what it did is, it issued shares, it also issued debentures, and whatever amount was still left was paid in cash. Clear? Now, Salomon was the MD and two of his sons were other directors. After 1 year, the company ran into financial difficulties and the debenture holders appointed a receiver and went into liquidation. The assets of the company were not even sufficient to discharge the secured debentures, and nothing was left for unsecured creditors. If I am talking about the company, what liabilities it had? It had some shareholders, which included Salomon, his wife, sons, and all, right? Then it also had some debenture holders, which again included Salomon, right? Secured debenture holders, and then it also had some unsecured creditors. Right? Whenever a company is liquidated, because the company ran into financial difficulties, there was no chance that the company can be revived back to the original situation, and hence the company had to be shut down. When the company had to be shut down, company's assets were being sold, and whatever amount was realized after selling company's assets was used to pay off liabilities. Now, even according to Companies Act, there is an order in which you can pay off liabilities. The first thing comes of secured creditors, then comes your unsecured creditors, and then comes your shareholders. Okay, so this is the order in which payment has to be made. According to this, payment was made to secured creditors, which was Salomon. So after paying to the secured debenture holders, nothing was left to pay to unsecured creditors. They were outsiders. They were not the members of family. So what they contended, they said that Salomon, it is Salomon's company only. Salomon himself is the director, Salomon himself is the shareholder, and Salomon himself is the debenture holder also. So it is his own company, and all the money that he has realized he has got it to himself, and the liabilities, it is not his personal liability. So who is going to pay my money? Creditors were very furious, were very angry, but it was realized and it was declared, the judgment of court came, Salomon is different and this company is different. Salomon, in the capacity of debenture holders, is entitled to receive money. Salomon, in the capacity of shareholder, is entitled to receive money. Salomon, in the capacity of even if he was an unsecured creditor, he would not have received money. So whoever you are talking about, the company is different and Salomon is different. Does not matter that Salomon himself was the shareholder, director, or whoever. Okay. So the said company comes into existence after its registration, and the company had been validly constituted. Like 7 members were required to form a public company, and so there were 7 members. Company had its own existence distinct from members, and a shareholder cannot be held liable for the acts of the company. Is this clear? Again, I am telling you this quickly only. Okay, because I believe that you are aware of these things. The next feature that comes is of limited liability. The liability of company, the liability of company is unlimited. What are you saying, ma'am? The liability of members of the company is limited. Once again, I'll repeat. If you want, you can write the same. The liability of company is still unlimited. The liability of members of the company is limited. Okay. A company may be limited either by shares or guarantee. You also have a provision, something called as unlimited company under the Act. Okay, so there can be an unlimited company also formed, but in usual cases what you have is the liability of the members in a company is limited. Supposedly this is a company and I have bought 10 shares of the company. That is, I have promised that I'm going to buy 10 shares of the company. Now this 10 shares of the company at 100 each. That means how much amount do I have to contribute or pay to the company is 1000, right? Out of this 100 each amount, it may be divided into different parts, that is maybe application money, then first call, second call, final call, something like that, right? So maybe on application I have paid 20, on first call I have paid 30. That means total amount that I have paid so far is 30 into 10, that is 300. But I have promised the company that up to 1000 I will pay to you because I have subscribed for 10 shares at 100 each. This amount is pending. This is not yet called by the company because company calls only that much amount of money from the shareholders that is needed for a certain project. Company will not call extra money. Okay, company may call the money as and when needed. So if a company wants to call more money, it can call more money. Since 30 has been paid, it can call 70 more. But it cannot call more than that. I am not liable to contribute more than this to the company, even if the company is drenched in debts and has to repay some crores of amounts to somebody. I am liable only to the amount of 1000. That means my liability is restricted only to the extent of unpaid money on shares held by me. And if it is a guarantee company, there are two types of companies. You have a company which is with share capital, a company without share capital. Even when you have a company with share capital, it may also be accompanied by some guarantee amount. Okay, guarantee amount, what does it mean? That the members take guarantee of certain amount. Supposedly, I have undertaken a guarantee of 50,000. Now, during the lifetime of the company, at the time of winding up, company can maximum call for 50,000 from me. I am not going to be liable for an amount exceeding the amount that I have guaranteed. Okay, so in case of company limited by shares, the liability of members is going to be restricted or limited to the extent of unpaid money. Here the unpaid money was 70, right? Or unpaid money was 700 in total. Limited by guarantee, it is the limited to amount guaranteed by him in the memorandum. Is this clear? If it is with share capital and guarantee, so guarantee amount also and unpaid share amount also. Okay. Next is perpetual succession. Perpetual succession. What do you mean by perpetual succession? Members may come and go, but the company goes on forever. A member may come, a member may die, a member may go. Supposedly, I have bought shares of Reliance today, and tomorrow the share price rises, and I am going to sell it. Will the company shut down? Because Shivangi ma'am is no more the member of Reliance, nothing is going to happen to Reliance. So any member may come, any member may go, company is going to be in. Okay, Company is going to be intact. See, there are definitely cases and situations that if there is some promoter, shareholder, director, somebody called as maybe Mukesh Ambani ji in Reliance, and if he leaves the company will not end. Legally, on paper, the company is not going to end. Company will still be there. He will sell the shares to somebody else, and that somebody else will come and take his place, right? So there's a legal procedure how you operate a company. Even if somebody dies, the shares is transferred to the legal representative of the deceased person, and he overtakes the company. Okay, so the company does not come to an end. Yes, definitely it can happen that somebody was very competent and the person who took his position is not that competent, so eventually the company ran out of profits and the company actually went into liquidation. That is a different thing. Okay, but members does not affect the existence of a company. So we are going to see a company on and on and on for a foreseeable future. Okay, however, when I'm talking about proprietorship business, it actually is the member is no more there, the business is also no more there. Legally it does not have any existence, right? Because it was that particular person only. Even when I'm talking about partnership, the partnership get dissolved, right? The business may continue. Now, common seal. The common seal is one such feature which has been made optional. Earlier, it was mandatory, but after Companies Amendment Act 2015, this is something that has been made optional. It is nothing but the official seal of company. Official seal of company. Many companies have this common seal. So on every document, that particular seal is affixed, and if they do not have common seal, because it is optional now, if they do not have common seal, there is a proper procedure as to who can sign a document, and when signed by those two directors, that particular document will be treated as an authentic one. Okay. Then comes your transferability of shares. What do you mean by shares and what do you mean by share capital? If I invest capital in my proprietorship business, it is known as proprietor's capital, right? If I invest capital or money in my partnership business, it is known as partner's capital. If I invest money in a company, the company in turn issues me shares, and that is why it is known as share capital. Now, whatever amount of money is collected from all people, say two of us have contributed to a company and started a company. I have paid 50,000, you have paid 50,000 to that particular company. 50,000 amount we have paid. Now, to ease and to split that capital into different parts so that it is easily accessible, if I have to invest in Reliance company and someone asks me that okay, can you give me 2 crore rupees, I'll say no, right? But if someone asks me, can you give me 2,000 rupees, I'll say yes, surely. If it is a profitable venture, very happily I'm going to invest 2,000 rupees. So that is why company is a bigger form of organization which needs more funds, right? So taking money from just one or two people is not going to suffice in the long run. That is why it is very important that this denomination should be kept smaller so that large number of people can invest in the company, and the company takes this advantage of many investors investing or contributing small amount, which actually in turns becomes a bigger amount needed by the company. So the smallest unit into which this share capital requirement is divided is known as one share. Maybe the company decides, okay, the smallest amount that I am going to take is 1,000. So the company's share price is 1,000. Now, if anyone wants to invest or buy the shares of that particular company, he or she at least has to give 1,000 rupees. At least you will buy one share because fractional shares are not traded. Okay, so at least you have to buy one share. I hope all these provisions, right, they are clear. Now, So the capital of the company is divided into parts called shares. The shares are said to be movable property, especially when I'm talking about a public company. In private company, there is restriction on transferability of shares, but in public company, the shares are freely transferable. You can transfer it to anyone you like. I want to sell my shares to you, I'm going to sell it. Doesn't matter. Okay. So there is transferability of shares. It is not available in partnership business. If I have invested in partnership business and I have my 10% share of profits and I want to transfer it to someone else, I cannot unless all partners consent to the same, right? But if I have invested 10% into the share capital of some company and I want to transfer this particular investment to someone else, I can, provided the provisions of Companies Act are followed. Then comes separate property. This is very clearly related to separate legal entity. Since company is a separate legal entity, it can also have the property in its own name. It can also sue and be sued in its own name. So both these provisions are related to separate legal entity only. Is this clear? So far, I hope everything has been recalled by you. What do you mean by company? What are the basics of Companies Act? Then what are the characteristics of a company? Right? What are the characteristics of a company? And I hope you have also understood the concept of separate legal entity, which is also important for this particular topic, that is corporate veil. You remember the case law of Salomon versus Salomon and Company Limited. Salomon and Company Limited, that means it is a public company. If you remember, if I'm writing ABC Private Limited, it is a private company, but if I'm writing ABC Limited, it is a public company, right? So when it was written Salomon and Company Limited, that means it is a public company, and in public company, you require at least 7 members. So at least 7 members are required to form a public company, which was very well present in the case of Salomon and Salomon Company Limited. Okay. Now, corporate veil. Corporate veil. Corporate veil is very closely related to curtain. You can see here, curtain. A curtain, what it does. What is the purpose of a curtain? Even at our homes or even anywhere, what is the purpose of curtain? To hide some, right? To hide some. That is what the purpose of curtain is, that we want only this thing to be seen, right? If we want the sunlight to come in, we will open the curtains. If we want the sunlight to stay out only and we do not want it to come in, we will close the curtains, right? That is what curtains are meant to be. The same thing happens here also. There is a veil of incorporation. See, I told you company is a separate legal entity. This is a company. This is a company. Unfortunately, it does not has eyes, mouth, ear, nose, whatever you call it. All these are not there. Artificially, we can draw like this, but actually it is not there. So company cannot see. Company cannot hear. Right? If someone comes to the company and says that since you are engaged in cotton manufacturing, I want to buy some cotton from you, will this company be able to speak, okay, I am ready to sell cotton to you? The company will not be able to speak, right? Although company is a legal person, yet the company will not be able to speak, and that is why company wants or company appoints, there are people, natural people who manage the company. Who manage the company, right? They are the owners of the company. And since owners cannot always, I am the owner of Reliance, right? Because I have the shares of Reliance. Shareholders are the owners or the members of the company. But I cannot run the company, right? So what shareholders do is they elect representatives to run the company. They elect representatives to run the company who are known as board of directors. Board of directors. So you have certain other people. Now this particular person, instead of going to the company, will come to these directors. Right? Will come to these directors, and these directors are actually going to say yes to this particular person. So who is dealing with the outsiders? These directors. But on whose behalf? Company's behalf. Now if company is unable to make payment to this particular person as and when required, this person is going to sue. This person is going to sue whether these directors or the company. Of course the company. Why? Because directors are different and the company is different. You are actually entering into a contract with the company. Only the medium of entering into a contract is the director, right? Directors actually act as an agent for the company. They're not the agent of the company, but they act as an agent of the company, right? So basically you are entering into a contract with the company only. That is the distinction which is made between the company and the director. Director, owner, whoever is involved in the decision making. So you get this point very straight. This differentiation is known as a wheel of corporation. That is, you are doing business with a company. You are doing business with a company. Everyone who is interested is only interested to know what the company is doing, how the company is doing. They are not interested to know about them, right? A company in law is distinct from its members. This principle is called as a wheel of incorporation. So once the company is incorporated, a company has its own identity. Anyone who is entering into a contract with a company, no matter whom he interacts with or through whom he reaches the company, is entering into a contract with the company only. That is known as wheel of incorporation. That is, you can say, corporate wheel refers to the concept that members of a company are shielded from liability to the company's action. The members, the directors, they are protected. No matter I have said yes, it is on company's behalf. So the liability will be of company only. It is not going to be my liability. So that is the protection these members, these directors have got, that whatever liability will be generated, it is going to be company's liability and not my liability, right? So corporate wheel implies that members should not be liable for those errors. If there is any default in payment, it is the company who is liable. Okay. In other words, they enjoy corporate insulation. Now, what is meaning of lifting off corporate wheel or piercing corporate wheel? This is basically lifting the curtain. So far, the identity of people who are actually working for the company cannot see. Somebody else is seeing on behalf of the company. Somebody else is speaking on behalf of the company. But they are hidden. They're protected from that curtain. Nobody can see them. That okay, this particular person is involved. This particular person did not pay my tax. You cannot see that person. But in cases where fraudulent activities are incorporated, then you have to remove this curtain. You have to lift this curtain. You have to pierce this curtain to see the real persons who are actually involved and doing all of this. If I have formed a company and I am doing everything in good faith and in order, I am being protected from any liability that the company is incurring. But But if I am actually indulging myself in fraudulent activities, that I'm taking loans in the name of company, but I'm actually using them, and I'm taking loans with the intention of not repaying it, the people, the government will actually lift this curtain and see who is the one who is doing this, because company cannot do this. There can be errors, there can be defaults, there can be omissions, and that is allowed. That we can do on behalf of company, that is not a problem. But in certain cases, it is very important, it is imperative to know and punish those people, because otherwise wearing that mask and behind that curtain, they will do anything they want to, right? They will control the company for their own benefit. That is something that cannot be allowed, right? So when the law disregards the corporate entity, law says, okay, separate legal entity, company different, member different. No, company is the same as member, because member is the one who is actually misleading the company. So when law disregards this wheel of incorporation and actually pays regard to the individual members behind this legal facade, that is mask, it is known as lifting of corporate personality. Now, corporate wheel is lifted under different situations, some under statutory provisions also, and you also have some under judicial interpretations. See, if I talk by fiction of law, every company is seen as a separate legal entity, but in reality what it is actually these association of persons who are actually the beneficial owners of the company, right? So this fiction is created by a fictional wheel known as corporate wheel, and when it is required that we must see who are the people who are behind the company, then lifting is being done. Lifting of corporate wheel cannot happen every now and then. That if something bad happens with you by the company, lift the corporate wheel and see who is behind. No, that you can definitely see legally who is going to see. That is what we are talking about. Okay, so every now and then this wheel cannot be lifted. This wheel can be lifted when it is permitted under the statute, that is under law. So you have different provisions, different statutory provisions. You must have read something called as misstatement in prospectus. That is a case where corporate wheel is lifted and the persons who are behind the company are being punished. Okay. So apart from the statutory provisions that we will read every now and then, we also have some judicial interpretations. So there have been great judgments telling us how or in what cases we must look behind the real persons who are actually doing this or engaged in fraudulent activities. Firstly, protection of revenue. In certain matters concerning the law of taxes, stamps, duties, where the question of the controlling interest is in issue. See, what happened in this particular case, there was a person who was receiving a lot of income from investments. Now, if he is receiving a lot of income investments, he also has to pay tax. What he did is, he formed 4 companies. Company, and transferred his investments to these companies. Now his income was spread over these different companies, right? So in his hands the tax slab reduced and the overall tax reduced. And what he did is, he transferred investments and he took loans from companies. A person had investments, he transferred investments, he formed a company, he transferred investment, and in turn he took loans from the company. So ultimately he had all that money that he wanted to hold, right? So his money hasn't gone anywhere, but he just shifted his investments in the name of a company. a sham company, a company which has no existence, no business, nothing. If it had business and these companies were formed for some other purpose also, and you would have transferred your investment, there wouldn't have been any problem. But this is a clear case of evasion of tax. You have formed these companies just to avoid taxes, which is not acceptable, right? So now, although this is a company and this particular person, I hope okay, this company and this particular person, they should have been separate legal entities, right? So members should be different from that particular company, but when calculating revenue, when calculating taxes, the wheel of incorporation which was between them was actually lifted. Okay, it was actually lifted, and their incomes were clubbed. Their incomes were clubbed to protect revenue. Right? So this was the case of Dinshaw Menegji Petit. Then comes determining the enemy character of a company. Determining the enemy character of a company. Daimler Company Limited versus Continental Tire and Rubber Company Limited. If you have read, you must have read, surely you have read, there is a concept in Indian Contract Act called as alien enemy. Alien enemy. What do you mean by alien enemy? Some country, supposedly you have India and you have Pakistan. When these both countries are at peace, they are friends. But when these both companies are at war, if you are entering into a contract with any citizen of Pakistan, that particular citizen, government, they are all alien enemy. Alien is someone who is outsider, that is outside India. Whether he is a friend or enemy is decided by the fact that Indian government is at war or at peace with that particular country. Okay, so recently China was one of the alien enemies, and so you could not contract with these people. Okay, so that is what alien enemy means. If you want to determine the character of alien enemy, then also corporate wheel may be lifted, as it happened in the case of Daimler Company Limited. There was a company which was formed in England. There's a company which was formed in England, and this company was made by you can say all the German people. Okay, so literally all the shareholders were of Germany only. Okay, and the directors were also German residents. Director also German residents. Now, what happened is, Germany and England, they became alien enemy at certain point of time. Okay, that is, England was not at peace with Germany. That means England companies cannot enter into a contract with German companies. Ideally, this particular company was an England company only. So England people could enter into a contract with an England company. There wouldn't be any problem. But this particular England company was only by the name England company, because all the shareholders were German residents only. So ultimately, every money, every decision was being dictated and directed towards Germany only. So if any England citizen enters into a contract with this particular England company, he is actually entering into a contract with Germany, which is not allowed because it is an alien enemy. So to determine the character of alien enemy, this particular corporate wheel between the company and its directors or its members was actually lifted. So now we came to the picture. That in these cases it can be lifted. In these cases it can be lifted. Next, where companies form other companies as their subsidiaries to act as agent, the application of the doctrine may operate in favor of such companies depending upon the fact of a particular case. For example, a company acquires a partnership concern. What is it doing? A company has acquired a partnership concern and converts it into a company. Okay, so this is A, this is B, and it becomes subsidiary of A. B becomes subsidiary of A. In action for compulsory acquisition of business premises of the subsidiary, it was held that the parent company was entitled to compensation and maintain action for the same, which through itself and nominees held all other shares was entitled to compensation and maintained action for the same. Now, what this particular case law is trying to tell us, see what is happening in this particular case. A subsidiary is being formed to act as an agent only. Okay, the purpose of forming subsidiary is not it is not so that there is a company and another company has acquired shares. They have actually bought the partnership concern and converted into a company to act as that particular agent of the company only, right? Now what happened is, this particular company held certain piece of land or whatever it is, and this was compulsorily acquired by the government, and the payment was to be made to this particular company. It was actually argued that whatever compensation on compulsory acquisition was to be given to this company should be actually given to this particular company, since this company was only acting as their agent. In this particular case also, corporate veil was lifted and it was decided that these two companies are actually the same. The next case is of Estate Officer UT Chandigarh versus SE's Information Technologies Limited. In this particular case, what is said is, lifting of corporate veil could also be done in case of transfer of shares of the company. Now, in this particular case, what happened was, see, there is a company, SEs, okay, and this was a subsidiary Indian company, subsidiary company in India. It also had, of course, it had its holding company, SEs Dubai, I believe. Okay. Now, what happened was, this particular company had got some land allotted. The land allotment rules said that this land cannot be transferred to someone else till 10 years, till the span of 10 years. Now, what this particular company did was sold all its shares to this company. Now, transferring shares meant transfer of all assets and liabilities also. And this company actually entered into a contract with some teledata for the use of this particular land. So there are much more facts than what I'm telling you, but I'm telling you all that is required. Now, this was a situation that although this transfer should be a valid transfer, since these are two different companies, members are different from their own company, so subsidiary should be different, separate legal entity from its holding company. But this transfer of shares is, in this particular case, this corporate veil was lifted and it was considered that these two people are the same. And that is why whatever transfer you're doing, that is in violation and should be stopped. Should be stopped. Okay. Because some other case was involved, teledata company. Then comes company formed for fraud or improper conduct. In this particular company, you have a case law, Jones versus Lipman, or you can also say one which is more popular, Guilford Motor Company. Guilford Motor Company Limited versus Horn. You don't have to remember all the facts and figures of all these cases, okay? Don't worry at all if you're not able to get what this case mean, what that case mean. Doesn't matter. You don't have to remember it. I'm telling you already extra. Something that you've already studied, something that you'll not be asked, okay? So all that you can remember, all that you have to remember is protection of revenue, the case law name, that's it, okay? So you don't have to remember all the facts and figures of the case. Clear? Now, what happened in this particular case, Guilford Motor Company Limited versus Horn? An employee entered into a contract with his employer that, just a second, that he will not solicit the customers after he has left the employment. So basically, there was a company and there was an employee of the company, and employee was leaving the company, and actually what it did was a contract or with the company that it is not going to take away all the customers of the company. After leaving the employment, what he did was incorporated a company in which he was there, his wife was there, and they started soliciting the customer. So ideally, who is soliciting the customer? This particular company, which is distinct from the employee, and employee was prohibited to solicit the customers. So ideally, this company was soliciting the customers. And if company is considered as different from its employees, that means employee is not at fault because this company is soliciting the customer. So in this particular case, this corporate veil between that particular employee who opened the company and the company he opened was lifted, and it was seen that this is the employee only who is soliciting the customer in the name of the company, and so he should be punished. Then came company avoiding legal obligations or welfare legislation, the very famous case of Workmen of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. Now, what this particular company did was, they had a lot of workmen. So this particular company was generating heavy income by way of all the investments, and because of its high income, it had to pay high bonus by virtue of the legal statutory obligation, right? So what this particular company did was, it formed another company and transferred all its investments to that particular company. What happened? The result was that income in this particular company got reduced, and that is why the bonus to be paid to workmen also got reduced. It was later on discovered that this particular company was formed only to avoid this legal obligation of paying bonus to the workmen who were entitled by law to receive bonus. So that is why this corporate veil between this company and this company was lifted, and it was seen that who owns this company. Whoever owns this company, the income is going to be merged in the hands of this particular company, and accordingly high bonus is going to be paid to the workmen. I hope it is clear. Now I have tried to keep it short, yet I have tried to explain you all the things, and in the next class we are going to start with classification of company.